Here's what we're covering today: the 4 IP tools every creative needs to understand, why copyright is both your greatest protection and your most common trap, how trademark protects your brand and not just your work, when patents matter for creatives, and a practical step-by-step for what to do first. I'm Julie King of King Patent Law. I'm a patent attorney, a business attorney, and a lifelong horror and rock music enthusiast, which means I think about things that can destroy your creative business the same way I think about what is lurking in a dark basement in a horror movie, with relish and with the firm intention of helping you avoid the monster entirely. Let's get to it. When we talk about intellectual property, we're talking about 4 main categories: copyright, trademark, patents, and trade secrets. Each one protects something different, and as a creative, your work often touches multiple categories at once. Let's start with copyright because it is the most immediately relevant to the work of creating and the one most people have at least heard of. Copyright protects original works of authorship fixed in a tangible medium of expression. We're talking about paintings, drawings, photographs, music compositions, sound recordings, written works like novels and lyrics and screenplays, software code, architectural designs, film and video. The category is broad. It even covers things like marketing copy, brochure design, social media templates, and digital art. All kinds of things that creatives generate on a regular basis, whether in the world of art or for business clients. Now, the first thing I get asked about copyright these days is whether something created with AI can be protected by copyright. Of course, the answer is it depends. Unless the human puts significant creative effort into the creation or modification of the AI output, copyright will not protect it. Next month, I am doing a full episode on AI and IP covering copyright, trademark, patents, and the questions you are all asking. It's updated, thorough, and I am genuinely excited about it. Watch for it. Here's what most creatives know: copyright is automatic. The moment you create an original work and fix it in tangible form, whether that means writing it down, recording it, or saving the file, you usually own the copyright. You don't have to register it. You don't have to put a copyright notice on it, although that remains a good practice. The protection exists from the moment of creation. Now, here's what many creatives do not know: automatic copyright and registered copyright are not the same thing at all in terms of what you can actually do with them in court or what you can do when submitting Digital Millennium Copyright Act or DMCA takedown requests in the US or equivalent takedown requests abroad. For online takedowns, you can submit a DMCA notice without registration, but if the alleged infringer files a counter notification, you have 2 weeks to initiate court action or the content goes back up, and you cannot file that court action without a registration in place. Which leads to, if someone infringes your copyright and your work is not registered with the U.S. Copyright Office, you can still sue, but only after you register. If you register at that point rather than before infringement occurs, your recoverable damages are limited to your actual losses, which are often difficult to prove and often modest. You cannot recover statutory damages, which under the Copyright Act can range from $750 to $30,000 per infringed work and up to $150,000 per work for willful infringement. You also cannot generally cover attorney fees. Next, we have trademarks. Trademarks protect brand identifiers, words, names, symbols, logos, and other devices that identify the source of goods or services in commerce, like signature packaging. It protects your brand, not your creative work itself. If you're a freelance illustrator, copyright protects your illustrations. Trademark protects your business name, your logo as a brand identifier, and maybe a tagline you use in commerce. 2 different things, 2 different protections. Most serious creative businesses need both. For creatives who sell products, merchandise, prints, handmade goods, music, trademark is especially important because it prevents someone from putting your name or logo on their inferior products and confusing your customers. Now, what about patents? Most creatives do not immediately think about patents, but there are 2 types that are directly relevant to product-based creatives: the design patent and the utility patent. A design patent protects the ornamental, non-functional appearance of a product. If you design a uniquely shaped piece of jewelry, a distinctive piece of furniture, a product with a specific visual design, a design patent can protect that appearance and prevent competitors from copying it. Design patents are generally less expensive and faster to obtain than utility patents. Now, while a design patent protects how something looks, a utility patent protects how something works. Anything from an apparatus that helps an artist create something in a special way, to a new guitar effects pedal, a chemical formula for a kind of paint or resin, a method of creating something, and more. If you make products with distinctive visual designs, design patents are worth a conversation with a patent attorney. And if you've come up with something truly innovative, it may well be worth exploring a utility patent as well. Sometimes it makes sense to protect a design through both trade dress trademarks and design patents. For more on that topic, please check out my posts, Trade Dress Trademarks versus Design Patents, Doubling Product Design Protection via Design Patents and Trade Dress Trademarks, and Trademark Lawyer Tips, The Secret to Immortal Design Protection. Finally, we have trade secrets. For creatives, trade secrets might mean a proprietary process, a technique, a formula, or method that gives you a competitive advantage, and you keep that confidential. Trade secret protection is available without any registration as long as you remember to take reasonable steps to maintain secrecy. We'll cover trade secrets in detail in a future episode, and you can check out my short called Trade Secret versus Patent, Which One Should You Choose? Let me give you a concrete sequence of steps that will help you protect your creative work. Step 1, identify what you create. Make a list. What are the copyrightable works you produce? What are the brand identifiers associated with your business? Start with an inventory so you know what you're protecting. For content creators and influencers, that list includes your content library, your handle, your visual brand, and any signature phrases or formats you have made your own. Step 2, register your most important works. For works that represent significant time investment, have commercial value, or are especially vulnerable to copying, register with the U.S. Copyright Office at copyright.gov. If you produce a high volume of works, ask a copyright attorney about group registration options, which allow you to register multiple works for a single fee. Step 3, file a federal trademark application for your brand identifiers. If you've been using your business name and logo in commerce, you likely have common law trademark rights, but those rights are limited to your geographic area of actual use. A federal trademark registration provides nationwide rights, a legal presumption of ownership, and the right to use the registered trademark symbol. Before you file, get a comprehensive trademark search, not just a USPTO database check. Common law marks matter and can block your application. Step 4, get your contracts right. Every client engagement should be governed by a written contract. Every single one. The contract should specify what you're creating, what rights the client receives, whether it's a license or an assignment, the scope and duration of any license, how payment works, and who owns work that is not delivered or paid for. You all know that happens. Make sure you retain the right to use the work in your portfolio if you want to. If you're regularly using a form contract, have an attorney review it. Generic templates from the internet are not written for your specific situation or your state's laws. Step 5, document your creative process. Keep dated records of your work, drafts, sketches, version histories, project files, emails. In a copyright dispute, your ability to demonstrate independent creation, when you started, how the work developed, is valuable evidence. Cloud storage with automatic timestamping is your friend here. Step 6, know when to call an attorney. For copyright registration of straightforward works, you can generally handle this yourself. Now for trademark, work with an attorney. Trademark law is more complex. The categories matter, the search matters, and a rejected application costs money and time. For contract review, anytime you see language about work for hire, assignment, or IP ownership that you do not fully understand, get a review before you sign. The cost of a contract review is almost always far less than what you unknowingly give away without it. That's all for now. Thanks for watching or listening. If you're ready to protect your creative work and the business you've built around it, book a consultation at kingpatentlaw.com. Avoid the legal horrors and keep rocking your IP. Finally, a reminder that this information is for educational purposes only, is not legal advice, and does not form an attorney-client relationship. For advice about your specific situation, consult with a licensed attorney.